A public defender walks into court alone, facing a police department backed by extensive resources and taxpayer-funded legal representation. Attorney David Westbrook has just returned from Oklahoma, where he was working to save the life of someone on death row, and now he finds himself facing another urgent legal battle. This is Judge Eric Goodman's courtroom in Department 11 of the Las Vegas Township Justice Court in Nevada. Westbrook represents Joshua Sanchez Lopez, who remains in jail despite a judge previously ordering his release. According to the defense, the Las Vegas Metropolitan Police Department refused to process that release order. The case raises serious due process concerns under the 14th Amendment, which protects individuals from being deprived of liberty without proper legal process. However, before Westbrook can fully present his argument, Metro files a new legal brief just 36 hours before the hearing, leaving the public defender with little time to review and respond to the department's latest arguments.
That's Mr. Westbrook, and the motion you want to make.
I do, Your Honor. As I indicated to the court yesterday, the email with all parties on the email, I'm requesting a continuous to today's proceedings, and the reason for that is simple. About 36 hours ago, I don't know, my timeline is a little tough, so I just got into the airplane from Oklahoma. About 36 hours ago, Metro filed a new supplemental briefing. I haven't had a chance to even read it, much less respond to it. And I want to file a response in writing, which I think is our right. All that it takes for continuance is good cause, and their late filing is my good cause. There's other reasons that I can present, but I want to start with that one.
But that's simply the order that Judge Mendoza actually entered. We actually have a written order now.
Well, we have a written order that in no way binds the court, number one. And number two, I need to actually address what the power of that order is. And here's the thing, this came up before, and I'm actually surprised that Metro wouldn't just simply agree to the continuance in this case, since they've been asking for stays nonstop in all these cases. But here's the issue. When you were in front of Judge Mendoza, Metro filed their brief in that case, kind of a 25-page brief with a bunch of exhibits, at 5:50 p.m. the day before the hearing. It wasn't served on properly. I didn't get it until we appeared for oral argument and it was handed to me. I got somewhere between 20 and 40 minutes to read it. And we were in a situation there where I could not ask for a continuance to fully brief the issue because my client had been ordered by the court onto medium-level house arrest. House arrest refused, told the judge, we're not following your order, and said, but you're going to lay him on house arrest. So he was pumped up to high-level house arrest in that case. The problem is that was going to interfere with his job, and he was afraid of losing his job. So I had to go forward then. Also, the sentencing was right around the corner in that case, and it would have damaged my client. I believe that was the case I'm thinking of. It would have damaged my client to have the sentencing continued, just because I'm briefing this issue. So I could not, in that situation, ask for a continuance to file a written motion. I got it with about 20 to 40 minutes to read it. And I went up there and argued this brand new issue that I had never seen before, with arguments I had never seen before, on a motion that I was never even served with, and did my best in front of the court. Now, subsequently, I asked the court for an opportunity to actually brief the case. And Metro opposed. So their argument was, you should have asked to continue it, and you should have asked to brief it. You didn't do that. And so we're going to oppose any opportunity to brief it now.
Court. Talk about my court.
I'm sorry, Judge Mendoza. I'm not talking about it. Yeah, I'm talking about Judge Mendoza.
I need to keep certain.
Yeah, I am. So I asked Judge Mendoza for an opportunity to brief it, and I filed a proper after the hearing of arguments that I would have made had I not been shut down. There's also a lot of oral argument I was trying to make in that case that I was shut down on, and Judge Mendoza wouldn't hear. So I was denied the opportunity to brief it in front of Judge Mendoza, and their position was you should have asked for a continuance. Well, now we're in a similar situation today. They just filed something to the court. I have a right to reply in writing, and I'm asking for a continuance because my client's not in a situation where my request for continuance will hurt him. So
this case is in front of the Nevada Supreme Court at this point, is it?
Yes, it is.
With 3 other cases?
Yes.
And it's being argued in front of the Supreme Court.
It is being argued in front of the Supreme Court. However, we've all agreed that the contempt issue is not moot.
But that's what happened with Mendoza. She's the higher court. She discharged
Right, but she's not. She. First of all, again, I need to address that in writing. If I'm not allowed a continuance to file a written brief, then I'm in the same situation here as I was in front of Judge Mendoza, and the court would be in a situation where you don't have the full information of the full law in order to hear this argument. And we want to avoid summary decisions. I mean, part of our complaint about what Metro is doing on Mr. Dickerson's advice is that they're making summary decisions behind closed doors where nobody is present. There are no checks and balances. They don't even have a consistent format for rejecting or accepting people to their programs. They won't share the information with us, and we're not allowed to appear and present our case. And what they want to do is turn courtrooms into the little back rooms where they make their decisions.
Is this the motion we continue, Your Honor?
Yes, it is.
What is it?
It's my motion. Okay. Well, I appreciate you calling it nonsense, Mr. Dickerson. I know you think due process is nonsense, but I happen to disagree with
I
it.
just think they diatribe here.
Thank you.
What Westbrook just described goes to the heart of the separation of powers, a fundamental principle of the American constitutional system. Courts determine bail and issue release orders, while law enforcement is responsible for carrying out those orders within the law. The legislature creates the laws, and each branch of government has its own defined role. This structure was designed to prevent any single government authority from gaining unchecked power. In this case, the defense argues that Metro effectively refused to act on a judge's release order because it disagreed with it. If that is what occurred, the issue goes beyond a simple policy disagreement. It raises a serious question about whether one part of government can disregard a lawful order from another. The Supreme Court has repeatedly emphasized the authority of judicial orders, making the judge's response to this dispute a significant moment in the courtroom.
Like every lower court, I'm all with the upper courts. Whatever the higher courts tell me to do, whatever they're doing, I'm following what they're doing. I mean, she did discharge it. I mean, it took a while to get a written this wasn't filed until the 13th of this month. That was given to me by Metro, but she could discharge it up there. It's not the exact same issue, but it's adjacent to the issue in front of me. I mean, it's all in the same ballpark. Given that's what Judge Mendoza did, and she's a district court judge, I'm a justice court judge. I mean, I'm just going to dismiss the case down here. I'm going to discharge the order the same way that Mendoza did.
Okay. Well, we obviously object to that.
Oh yeah, of course.
They've agreed.
Rejected up there, going to
Right
down here.
And look, this is what they're trying to do. They keep sending me.
But you'll be in front of the Supreme Court.
I will be in front of
the decision.
I will be in front of the Supreme Court, but here's the issue.
Yeah.
They keep asking for First of all, Judge Mendoza's order in that case does not bind you in this case in any way, shape, or form. Okay, so let's put that out front right away. And you know who likes to make that argument? Metro. As you might recall, we had an issue a few years ago regarding the subpoena power of defense attorneys, where we had district courts saying that we had subpoena power, and Metro was arguing throughout that those district courts didn't make an order in this case, so therefore they don't apply. Now they're arguing the opposite. They like to argue both sides. Heads I win, tails you lose. That's not what the law allows.
Your Honor, we could stand here and go tit for tat all day long about these allegations.
Yeah, but but now the actual written order,
Yes.
that kind of controls down here. Verbal order kind of controls down here. If anybody wants to make records, you're welcome to make records. If people want Judge Mendoza ruled or her order, I'm just charging this. So if anyone wants to make a record, you're welcome to. But yeah, I'm just charging it.
Well, Your Honor, I'm in the middle of the record break.
Okay.
And this is my record.
Okay.
That is a violation of due process. They have agreed that the issue of contempt is not moot. Your Honor, you're the person who decides whether whether Metro committed contempt in regard to.
Hold on, that's not in bad faith. Let's find out in bad faith that they had no basis for what they did. They had a parallel action up in front of Mendoza, Judge Mendoza. It's not this issue, but it's basically the same issue. So when they denied my order, at least they had a basis, because there, at least at that point, there was the transcript. So that a basis would have been as nice as an actual order, yeah, but at least they had a basis for denying it. And I can't find that they acted in bad faith. I mean, the order kicked me, so I can't find the order that they acted in bad faith. So, I mean, I'm discharging this.
Well, you're-
not going to find any kind of contempt.
Thank you.
Your Honor, you can find.
He said it's a discretionary decision of this court.
I know. I read the order from them.
Your Honor,
Okay.
do you believe it happened in bad faith? Because it sounds to me like the issue that you actually do believe it happened in bad faith, but you feel restricted by an order from a district court that is not made the order in your case. I mean, that's why we're here. It's so that the court can actually rule on it.
They had a transcript where it looked like Judge Mendoza was going to rule this way, the way she ruled. And that's the way she ruled.
And she ruled without even giving you the opportunity to fully brief it.
You're in front of the Nevada Supreme Court.
I am President of the Supreme Court. But Your Honor, before you go on, I have to talk to you about my full record, and I have to give you the public interest angle on this as well as everything else. I've already given the legal angle, and I object to it. I think this is a violation of due process. But let's look at what's actually happening here. Metro keeps filing requests for us to agree to a stay of all proceedings on this until the Supreme Court is ruled. And my response to all of their requests to stay has been exactly the same. I will gladly agree to a stay of all contempt proceedings in all lower courts if Metro will agree to stop committing acts of contempt. They will not agree to that. They've created this completely false narrative in the media, which is designed to stoke fear. Mr. Dickerson is very good at going to the media and telling people to be scared of defendants, when what we should actually be scared of is this star chamber back room denial of people's rights without any due process. That's what we should be scared of. And he knows he's wrong on the law. So he's trying to go out there.
That's blatant.
I get to
This
talk,
is in a record.
I get to talk,
This
and then you
is
get to talk.
grandstanding.
And an ad hominem attack, Your Honor. This is not.
I want you to go back a few sentences and remember what you just said about me. Okay, so the point is, I think he knows he's wrong in the law. And so instead of fighting it in a courtroom, like today, he's fighting it out in the media. And he's trying to use fear. I know that the court's probably gotten phone calls from people with threats. I've gotten phone calls from people with threats. And that's an atmosphere that was created by Mr. Dickerson in the media.
And
Did
to
you
that
know?
point,
Hold on a second. Hold on a second. And no offense to the media. I don't care about the media. My dad has never cared about the media.
Yeah.
I don't really worry about death threats. It doesn't bother me whatsoever. What I worry about, what I care about, is what the district court does. Because we're the lower court.
I'm glad the media is here, Connor, because they're the fourth estate, and they're the ones who are going to actually show what's happening behind these closed doors. So I'm very glad the media is here, but the way Mr. Dickerson
They're
views the
welcome
media,
to. They're absolutely welcome to. They're in here filming this. They're absolutely welcome to do whatever
Absolutely.
they want. They'll do whatever they want.
then we're in
And what I
agreement.
care about at the end of the day is what did Judge Mendoza do?
Yes, and I am asking you for the opportunity, because if you don't give me this opportunity, then your decision is now summary, just like Judge Mendoza's decision was summary. I'm asking for the opportunity to brief this issue that was just handed to me by these guys 36 hours ago. I'm asking you to brief
It
it.
was something you knew was coming for weeks because you were there for the argument in front of Mendoza, and she pointed to the fact that she was likely to rule exactly how she
She wrote a 17-page order, which I haven't been able to brief, Your Honor. Okay, listen, if Mr. Dickerson's in a great position, because Metro has the ability to go and hire outside counsel to go do their work. All right, these are two private attorneys who are very good at their jobs that Metro is able to use taxpayer money to hire. I am a public defender,
Yes.
and
You
unfortunately,
your job.
thank you very much,
You're good at your job.
but I don't get to hire anybody outside. I've got a team of other public defenders who also have other jobs to do that are helping me, on this case. But I don't get to hire outside counsel to do all this work. I was just in Oklahoma doing death penalty work, and that is extremely important because I'm trying to save a life. And I come back here to this, and I ask for a reasonable continuance to brief the very issue you're currently ruling. And if you rule on it without giving me the opportunity to brief it, then it's another denial of due process, and it's a summary order. And my question is, what is the harm in letting me present my case? And I'll tell you what the harm is. They're wrong on the law, and so they want to try to debate this case in the court of public opinion, because in a court of law, they're going to lose. So they're trying to shut me up. It's like, pay no attention to that man behind the curtain. When someone says that, you pull back the curtain. And if you do, you'll find Mr. Dickerson there saying, please, dear God, don't listen to what he's saying, because
No, listen to
you'll
it.
agree with it.
It has no basis in law. He hasn't made any legal argument.
Yeah.
That's the
Right.
bottom line. He
I
has
have.
nothing.
Do you disagree that
No,
if I've been
it
cause
goes
for
here, this
continuance?
the Nevada Supreme Court. You know where it is right now? The Nevada Supreme Court.
That's right.
You know what I'm gonna listen to? You know what I'm gonna listen to at the end of the day is the Nevada Supreme Court.
Oh, we all are, Your Honor. That's their job.
Yeah.
But listen, in
And
the
I'm not gonna
meantime,
overturn a district court judge.
they're going to continue to violate clients' rights, and then they're going to go into a courtroom every single time I do a motion for an order to show cause, and they're going to say you can't rule on this, judge, because Judge Mendoza, based on one-sided briefing and a partial argument in an ambush hearing, ruled in our favor.
All of those comments that here is making are belied by the wording of the order, which he apparently has not read.
Right.
Because the Judge Mendoza addresses each and every one of these contentions that he's making. For example, Your Honor, he filed a giant proffer after she ruled from the bench, discharging the order to show cause with all of the arguments that he wanted to make in response to our brief. And she accepted it and considered it, and that's why it took over a month for us to get that written order. So all of these things, all of these issues that he's raising were addressed by Judge Mendoza before she wrote that order.
So I'm sorry, I think they're saying that I'm wrong on the law and that I'm wrong on what the order is. And what I'm saying is, I can show you that I'm right on the law and right on the order if I'm allowed to file a brief that's responsive to the pleading they filed less than 36 hours ago. So we both agree that I haven't made my point very clearly and I haven't cited to the law. So I'm asking to do that, and they're saying don't let him do that, and you're agreeing with them. That's a problem.
Your motion for continuance is denied.
Okay.
If you want to make any kind of record, you're welcome to make a record now that you made this.
Is the finding that I don't have good cause, or is the finding that you think you can't give me a continuance because of Judge Mendoza? I needed to know exactly why.
I was waiting to see what Judge Mendoza did. It's
Okay.
the exact same, I mean, not the exact same issue, but like I said, it's the same ballpark as what is happening in my department. All this is now in the Supreme Court. The Supreme Court will hear this. So save all your energy and all of this for the Supreme Court.
Well, I don't have to save my energy, Judge. I got plenty.
Anything?
No, Your Honor, thank you.
We object under the due process clause under the rules that allow me to file responses to motions that are filed by counsel.
We didn't file a motion, Your Honor. We filed a notice of supplemental authority, simply giving the court the written order that was in the transcript that we provided to you, and which has been part of the briefing all along.
Okay, it hasn't been because it's a new order. That's just not right.
Okay.
I haven't given enough to
Case is discharged.
Thank
Thank you.
You know what? We need to figure out the underlying case. Now that all this has happened, where's my? Oh my gosh, it's great for one.
Yeah, well, when Metro violates the law and it doesn't feel quite.
You know, Metro, you're free to leave.
Thank you, Your Honor.
Thank you, Your Honor.
The underlying case.
Get slandered some.
Don't talk to me about slander.
The Eighth Amendment prohibits excessive bail, while the 14th Amendment protects individuals from being deprived of liberty without due process of law. Read together, these constitutional protections raise an important question. Once a judge sets bail and a defendant satisfies the required conditions, can law enforcement continue holding that person? Metro's position is that Nevada law gives the sheriff independent authority to delay or block a release when there are public safety concerns. That statute creates a significant legal conflict between the sheriff's statutory authority and the court's authority over bail and release conditions, an issue that the Nevada Supreme Court may ultimately have to resolve. If law enforcement could independently override a judicial release order, it could fundamentally change how bail decisions are carried out across Nevada. The outcome could have broader implications for the balance between judicial authority, law enforcement discretion, and constitutional due process. What do you think the court should decide? Share your thoughts in the comments.